As you know, we have a couple of open positions on our court at the present time. So this week we have been ably assisted by two of our senior Court of Appeals judges, Judge Henry Green and Judge Steve Lieben. I have really not publicly thanked them for all that they have done to assist us this week. So on this last day of the docket, I would like to do that at this time. They have a very busy docket of their own, and so we really appreciate their giving us their time and assisting us this week.
Thank you.
Thanks for having us.
With that, I will call the first case on the docket. 113705, State of Kansas versus Brooke Dinkle.
May it please the court, Richard Ney, appearing for the appellant Brooke Dinkle. Madam Chief Justice, I would ask 3 minutes for rebuttal.
3 minutes is granted. Thank you.
Thank you. Your Honors, Brooke Dinkle was convicted by a jury in Saline County of 2 counts of rape of KH, a 13-year-old boy. She was sentenced to 14 years in prison. Her defense was that she had been raped repeatedly by KH, that this was non-consensual. The defense introduced at trial a Facebook message from KH admitting he had raped her and that he had blackmailed her into other sex. The state told the jury that she had fabricated that Facebook message. At a Van Cleve hearing granted by the Court of Appeals, we proved that contrary to the state's witness testimony, the Facebook message from KH was absolutely genuine from his account and exactly sent through the metadata at the exact time that Brooke received it. Nonetheless, the Court of Appeals upheld Brooke's conviction, and we are here based on a petition for review. At the core of the Court of Appeals panel's decision is what we submit as a legally erroneous holding that KSA 215503, sexual intercourse with a child under 14, is an absolute liability crime. Now,
and so doesn't that render any, if that is the holding, what the Court of Appeals did with what you just talked about, the Facebook message being accurate, not accurate, really doesn't render that meaningful, does it? It's just an absolute liability crime. Therefore, irregardless of what the Facebook message says, that doesn't matter, does it?
well, that was the Court of Appeals' position, and
don't you have to clear that hurdle first of what the Court of Appeals did on the absolute liability?
Certainly. Now,
Okay.
Part of the problem, Your Honor, is the fact that that question was never raised in the district court,
Right.
was never raised in the state's brief. I heard about it the first time during oral argument in this case in the Court of Appeals.
And it was the panel that questioned about that, wasn't it?
Yes.
That was not the state's position.
Oh, no, never. So after picking my chin up off the ground and beginning argument, I mean, that's what we danced with. But we never had a chance to brief that issue. Now, in our petition for review, we do address that, as we would have, perhaps more fully, if we had had a chance to brief it. If you look at this court's case, State versus Prime, the 2009 version, not the 2013, Your Honor, this court said that rape of a child was a general intent crime.
How does Prine play a part in this, at least the 2009 Prine case, when the statute has been completely altered with it when it comes to culpable mental states? We don't deal with general and specific intent anymore.
Well,
So what is the mental culpability requirement now for rape of a child under 14? Or is there one?
Well, we believe there is one. And if you look at the...
And what is it?
Okay. It's a general intent crime, that you have to intend to do this. And we look at the Lewis case, which says that, look, we don't create crimes in Kansas without some kind of intent. especially in very serious offenses. And again, we have the guidance of the statutes, 215202, which states that a culpable mental state is an essential element of every crime, and 5201, which requires a voluntary act before a person may be convicted of a crime. Well, let's look at that. There's not only no mens rea here, there's no actus rea. How can you have a crime?
Why don't you hone in on the actus rea? What is
Certainly.
the voluntary act requirement? Isn't there a voluntary act requirement in all crimes?
Well, yes. And if you're raped, if a 6'2", 170-pound person rapes you, whether he's 13 or 30, I don't consider that an actus rea. That's not a voluntary act on Brooke Dinkle's part.
Mr. Ney,
Yes.
I have a kind of a more global question, first of all. The reason that we at least had the initial colloquy about intent, or a necessity of some kind of intent or mens rea, is because of the defense seeking to use a mental disease or defect defense, right? That's why
Yes.
it matters. Now, if you have another route through the actus reus, that probably this probably doesn't apply. But to me, I look at this case as a coercion case, just a flat-out, old-fashioned coercion defense, like the alleged accomplice in a bank robbery who's only an accomplice because he got threatened before they walked into the bank. Was that pursued at
Well-
any point, or?
And here's the problem, Your Honor. I think defense counsel, Mr. Struble, he dealt with the first rape, but remember, that wasn't charged. The December 26th incident was not charged. It was subsequent contacts. Now, I guess Mr. Struble wasn't privy, and we would have raised this too, to Justice Rosen's opinion in State versus Brooks, where blackmail itself is rape. In Brooks, very much like this case, the defendant there told the victim, I know you had sex outside of marriage with someone else, so now you're going to have sex with me. And the defense was, well, that's not rape. And this court said, and all the four members who were on in the majority of that panel are still here, this court said it is. So not only was there one rape, there was repeated rapes, because we know, and you look at the Facebook message, that these were all coerced, first physically, and then subsequently by the use of blackmail, if not physical.
So I'm still trying to
Okay.
understand the answer to your question, or the answer to my question. So I agree
Yeah.
with you that argument looks pretty obvious, that these were coerced acts, which makes them non-criminal on her part, even if the crime requires intent or doesn't require intent or whatever. I mean, coercion is coercion is coercion.
Right.
So, but you're saying that was not raised?
No, it was rape, certainly rape, and that Brooke was suffering from post-rape syndrome.
But that's different. I think a mental disease or defect defense is different as a matter of law from a coercion defense, and frankly, a lot more complicated and steeper hill to climb. And so that's what I'm getting at.
I don't disagree, Your Honor.
Okay.
The problem we have
So
there...
coercion as coercion wasn't pursued.
Right. Well,
Just flat out, not roping in mental disease or defect.
well, it was pursued in the sense that it rape trauma syndrome
Okay.
and Brooke's actions after that to explain what she did.
And that's because the initial act was not charged, only the later
Yes.
acts.
Yes.
Okay.
Again, I can't read the defense counsel's mind.
Got it. Okay.
But the problem there comes then for us is that the Court of Appeals panel said, look, we don't have to reach any of this, basically, because since it's not a defense, there's no defense here, even to the sense that it was coercion, apparently, we're not reaching any of this. The Court of Appeals said if you have sex with a 13-year-old, whether you're forced or not, you're guilty of the offense. That's a pretty stunning statement, And from that, if you read the Court of Appeals opinion, it's basically the dominoes that fall said, well, we don't have to look at this because it doesn't matter. We don't have to look at Dr. Hutchinson's testimony. We don't, because none of it mattered. She had sex, forced or not. And they said it doesn't matter that the Facebook posting was actually genuine because, again, she had sex with him, whether it was coerced or not. And if you look at that Facebook post, I mean, number one, it's incredible evidence of Brooke's position, where KH is saying, it doesn't matter if you didn't want to first. He's saying, you didn't want to do this. You said no, because I'm 14 and you are 32, so it's still your fault. Tell anyone, and everyone will know we effed. And then he says how she has to pay him money. He's demanding $800. He's demanding, and that is borne out by his text messages to her. That he is in the coercive position. He's threatening her, tells her to die, tells her he's going to put her in prison for the rest of his life. But again, when that Facebook message is presented, the state is allowed to call a witness over defense objections. An officer who says, I play around with Facebook and I've used it in some investigations, but has no computer expertise, to say that that was falsified.
If we decide that there's no mental culpability requirement under the statute and section that was charged, sexual intercourse with a child who is under 14 years of age. It doesn't say knowingly like the other sections do. Would the mental disease or defect evidence be admissible? Because it does require that it rebuts a culpable mental state. Here there is none. How would you get to that?
Well, I think you'd get to it this way. The state took days putting on evidence about how Brooke acted, what she did after the December 26 rape, and that would counter, this kind of evidence of rape trauma syndrome would counter of why she was behaving that way. So I don't think the state gets the option to put on, well, she's still having contact with him, she's doing this, she's doing that, but not be able to put the counter of at least putting on the mental health evidence to show why she is and what a fragile state she's in. She's been abused before. I mean, it went to her whole pattern of character, which the state was happy to get into as it related to this case. They also put on evidence that KH was not violent and didn't do this sort of thing when, in fact, there was absolute evidence in his own postings that showed that he did.
And let me, you're about out of time. I'm
Yeah.
wondering the practical effect of this. If you prevail at some point, it would require a new trial.
Yes.
And what would happen at the new trial? Here the jury, interestingly, was instructed that that your client had to act knowingly. That may be right, maybe it's probably wrong. How is it that the jury is instructed with your theory that it requires some sort of voluntary act?
Well, the new trial could certainly be, as Judge Beyer is saying, based on coercion as opposed to a straight mental health situation.
You really never argued that, but okay.
Well, no, but we're talking about a new trial where I guess all bets are off, if you're asking how a new trial would go forward. But, I mean, you look at this, and the damage that was done is incalculable when you look at a defendant being presented in court, not just of having done this, but having fabricated evidence for the jury.
Well, what would the instruction have been, though, in response to Justice Rosen's question, if you had the original theories for what was required for a voluntary act?
Well, I would argue, if I were trial counsel, that the knowing still applies. That our arguments here say that it has to be at least a general intent crime, whether the statutes have changed or not. The Court of Appeals based its position on an unpublished 2014, I think, case and now there's this unpublished case. We really don't have a ruling on that.
Whether knowingly is required. And
Yeah.
that's what you got, apparently.
You
Maybe
did get it. Yeah,
through
that's
some-
what
Right.
you got. I
maybe
don't see
through
where
some
it is.
fluke. So I think what Justice Rosen's trying to get to, and maybe Judge Levin, is that we, if that's all that you're complaining about, you already got it. But that's not all you're complaining about, because you're
Hardly.
complaining about all the evidence that did or did not come in, et cetera.
The evidence that came in that my client committed a fraud to the jury who's trying her, which was false. I mean, our computer expert said this was a genuine Facebook message, and you look at this message, and it absolutely supports the defense here. And you look at all the text messages where KH is sending these things, give me money, give me this, I want guns, buy me guns, which were never put in, which was part of the, our Van Cleve.
And you're arguing that, or your argument is that the Court of Appeals never properly considered that because they just cut you off at the knees, as it were, based on their legal holding.
Yes, I
If we
felt
agree
fairly.
with you on that,
Yeah,
should
absolutely.
we remand to the Court of Appeals?
I think this court can look at this without a remand and look at this evidence and say that a new trial is warranted. I see I'm out of time. Yes, sir.
Thank you, Counsel.
Thank you.
Good morning, Madam Chief Justice. May it please the court. Amy Norton again on behalf of the state of Kansas. I guess to start with what Mr. Ney has been addressing, the Court of Appeals ruled that this was a strict liability offense.
Do you agree with that in the context of a forced sexual intercourse, that there is no defense to rape of a child? Do you agree with that?
I agree that that is what the legislature has written, yes, and this court should interpret the law as the legislature has written. Now, Mr. Ney's argument is a policy argument for the legislature to consider changing the law, but the case that the Court of Appeals based its decision on, the Prieto-Hernandez case, the defendant there made the same type of argument that considering it a strict liability offense would, take out of, not account for accidental conduct.
Is
there.
that really true of all strict liability crimes? That's what I'm struggling with. So presume for the purpose of my question that speeding is a strict liability crime. Like if you're driving over the speed limit, you're guilty no matter what. But what if the passenger reaches his foot over and stomps on your foot on the gas? I mean, is it true that strict liability crimes foreclose any kind of argument of involuntariness?
Yes, I think that's what the case law says, is that if the legislature is going to deem something strict liability, that means you're guilty. If you did the act, you are guilty. How
Well,
or
that's
why?
the question, if you did the act.
So-
I mean, isn't that the heart of that voluntary, involuntary question is, did you do the act? That's why I'm not so convinced by the state's argument that there is no wiggle room in a strict liability crime to analyze voluntariness.
I think there's two different considerations there. I mean, is there some charging considerations on behalf of the prosecution
What-
based on a factually
Let me
specific
ask this,
thing?
what if
But-
the defendant in this case had been comatose?
Again,
Is she still guilty of rape?
under the way the legislature has written the statute,
That's the state's view of strict liability.
the state's view is, as the Court of Appeals found, strict liability means if it happened and she's admitted that it happened, then she is guilty.
So in this instance, that's what I thought your position is: unconscious, comatose, unaware. That would still suffice. You could charge that person who's comatose with rape.
Under Prieto-Hernandez, they addressed
I
that specific
think-
concern and found that yes,
Could you charge both? Could the victim in this case and Ms. Dinkle been charged? You could have charged. You can charge a 13-year-old who's, in this case, 6'2", 170 pounds, with rape of an adult, can't you?
yes,
But in your scenario, both would be guilty of rape, right?
Well, under Mr. Nay's theory of the case. Under
No,
Mr.
they
I'm
wouldn't. They not your theory. Your theory is that
Oh, I'm
is
sorry,
that is that
I'm
is that both would be guilty of rape.
That's inescapable under your
Yes,
theory.
I'm sorry. I misunderstood. What
Yeah, but
you said.
isn't that right?
If the factual pattern is that the 13-year-old did forcibly assault the adult, then
they would both be guilty of rape.
legally, yes, they could both be charged and convicted.
Okay. I think you opened with Mr. Nay's making policy argument. This is a question for the legislature. The legislature wrote the statute. The court's bound by that. And you're right. That's the traditional way we do things. But we do have this doctrine of absurd results. Where does that play here? At some point, it does become just a bit absurd, doesn't it? A comatose woman.
Again, looking at the plain language of the statute, and again, I feel like this court's making, at this point, going down more of a policy consideration. And,
Isn't
and
policy
getting,
always somewhat involved when we say something's reaching and would force us to an absurd result? Isn't that inherently a part of absurd results? Somebody has to make a judgment about what's absurd.
yes, but traditionally that's been a very rarely used avenue by this court.
Don't
and
you
it's-
think the rape of a comatose woman might be such a rare situation?
And that's where, again, charging considerations on behalf of the prosecutor would come into play.
Apparently, they
but
didn't here, though, did they? I mean,
Those types
you
of-
can't fall back on we can rely on the executive. I mean, that's why absurd results exists, because sometimes if it's the prosecutor who's made a decision about whether to bring a case, the prosecutor has not been deterred by what is an obviously absurd result. Right? So doesn't really get to my question. The court is empowered, is it not, to say that in certain situations, the letter of the law reaches an absurd result.
Yes, the court is empowered to say that.
Well, let's talk about just principles of construction and interpretation of the statute and how we apply KSA 215203B, which provides, it authorizes us to dispense of a culpable mental state. And now I'm quoting, if the crime is a felony and the statute defining the crime clearly indicates a legislative purpose to impose absolute liability for the conduct described. How does this statute indicate a legislative purpose to impose absolute liability? Is it simply by silence?
I think the court has to look at the way the statute used to be written before the recodification, in which previously rape was defined as intercourse with a victim who does not consent when the victim was overcome by force or fear. The only time previously that a mental state type language was used was in the medical provider. When you get a knowing misrepresentation that a procedure is necessary, that provision of the rape statute. After the recodification, however, every single provision of the rape statute starts with or specifically includes the word knowingly, with the exception of this particular provision. And so that, I'll get the Latin wrong, but the inclusion of one and the exclusion of others rule, I think, comes into play here, where if the legislature is going to be so specific in starting every single alternative type of rape with a knowingly, the person must knowingly do this, and then when it comes to child rape, specifically not include that language, then I think that is a very clear legislative signal that they did not intend to include the word knowingly or include a mental state for the charge of child rape.
And I understand that's a way we would sometimes look to see, to compare the two provisions. But I'm wondering if that's enough under this statute where it says that they must clearly indicate a legislative purpose. It doesn't seem very clear when we're having to apply other rules of statutory construction to get there.
Well, again,
In other words, you're relying on what arguably is an ambiguity as compared to this statutory language that requires a clear indication.
well, I think the plain, we always go back to what's the plain language of the statute. The plain language of the statute does not include the word knowingly when the legislature, again, specifically included it for all the other versions under the rape statute. So I think that
But this provision contrasts with the provision that says there can be silence. Because this adds to that and says that if there is silence, to get to absolute liability, there has to be a clear indication. So how do we reconcile that?
I think you do what the Court of Appeals did and what the Prieto-Hernandez case did, which is you look at 215204B, which specifically says that the state does not have to prove that the defendant knew the child was under the age of 14 as an element of the offense. So when read in conjunction with the plain language of the child rape statute, again, as the Court of Appeals found in both this case and in Prieto-Hernandez, again, it's not only the plain language of the statute, which specifically does not include it, but then we have an additional statute that's even further reducing what the state has to prove in terms of the defendant's intent.
Or knowledge.
Which lends credence to the legislature's intent that this be a strict liability offense.
What about the questions you've heard during the argument regarding voluntary act, the necessity of a voluntary act by the defendant in order to have committed a crime?
I didn't hear the first part of your question.
I'm sorry. We've been talking during this argument, there have been several questions about the necessity of the defendant's voluntary act to commit a crime. What's your response to that line of questions? Is that dispensed with just because a culpable mental state is not required?
I think it would have to be. DUI is always kind of
There's a
the
statute that says you must have a voluntary act, right, to commit a crime?
there is.
And the recodification didn't do away with that.
I don't believe so. No.
So even if you're relying on silence to make a clear, for the legislature's clear intention to dispense with a culpable mental state, it's not silent in that statute, and it says that a voluntary act is necessary. So if in fact that's the case, I have another question for you that's just about what happened here. Did you try this case?
I did not know.
Okay. Do you know whether just a straight out coercion defense was ever advanced?
Once it became clear that the court was not going to allow the mental disease or defect to come in under that statute, I think it can really only be characterized as a coercion defense, is what Mr. Struble shifted to in presenting the evidence that he did to explain why she did and acted the way she did. One thing we have to remember is the state charged the vast majority of these counts under a date range starting in November 23rd and going through March of the next year. So the defendant's evidence was trying to show, I don't think it can be characterized as anything other than shifting to a coercion defense, really, that yes, it happened, but she didn't do it voluntarily and therefore shouldn't be guilty, and because she was coerced into it.
And is the significance of the date range that the first act wasn't charged, the one that she said was actually forced?
The act that she's claiming was forced was in late December, but the state's evidence...
So that wasn't a date range?
That's within the date range. The
Okay.
state's evidence, though, was that the first act actually occurred on or about November 23rd, so about a month prior.
But you didn't
Okay.
charge specific dates, so couldn't it have had, I don't understand either the Court of Appeals kind of recitation about the date and yours. What difference does it make? Why, if you charge a date range, couldn't the jury have found that December 26th was when the forcible rape occurred and everything else was after that? Why isn't, when you charge it that way, why is the defendant precluded from making that point? The forcible rape happened December 26th. I remember when that happened. She was very specific. It was forcible. She did nothing to consent to that activity. So what's your point about the date? I mean, yeah, it could have happened in November, but you didn't prove that it did. You just said you proved it's happened during this time range. I don't understand that.
I think the state's point about that was that the KH in his testimony was very clear as to when the first sexual encounter occurred, and that it was in November, not December, not this forcible assault. But a lot of the state's additional testimony about what happened after the date of that supposed forcible assault was because it's still within the date range of the offenses charged, and KH testified that this happened, that there were, I think, approximately 20 different sexual encounters.
You don't know which ones they convicted on, though, do you? I mean, you charge it in a range that you charge about 20 charges and they convicted on 2, right?
That is what they convicted on, yes. And I don't believe the jury specified a date in their verdicts. I'd have to refer the court back to the record for that, but
The Court of Appeals made a statement that they can't conceive of an instance where the state would prosecute an adult who was forcibly raped by a child. Isn't that what happened here?
no, that's,
Isn't that what you did? I
What
mean,
the defendant says she did anyway.
yeah,
Yeah.
isn't that what you did? I didn't, and that's,
if the, well, that is
they
the
couldn't conceive
defendant's
of it,
theory.
and that's what occurred here, or at least that's the defense.
That is the defense. Obviously, the state would strongly disagree that that's actually what happened.
Right. That's what a trial's about, but that's the defense. And so, what's your response to that?
That's obviously not what happened. That the state did not charge an adult who was forcibly raped. The state charged an adult who who herself initiated the sexual encounter with KH, that she began that encounter a month before she claimed she was forcibly raped, that she bragged to her friends about how good the sex was with her very young boyfriend.
Does any of this matter if, or because the jury, let me rephrase, if the jury had believed the defense that this was coerced, under the way the jury was instructed, they would have returned a not guilty verdict, it seems to me. Would you agree with that?
Yes, if the jury believed that all of that basically this sexual relationship started with the forcible rape and everything that came after was coerced, logically they should have
Because they
returned
were
the-
instructed that they had to find that the act was knowing.
They were instructed as to that, yes.
Even though you're saying that was wrong, that's still what happened here.
Yeah, that is
So
what happened.
what do we do with the defendant's argument that even if that's true, the Court of Appeals never really considered the evidentiary claims?
I think if this court's going to find that the Court of Appeals was wrong on the strict liability issue, I think a remand to the Court of Appeals for a review of the evidence and the issues in light of what this court would hold as the correct legal standard is the appropriate remedy.
If in fact we say that knowing was the correct legal standard.
If that's what the court finds, yes.
What was it, because they could be wrong without us finding that, and then that would be a new trial, wouldn't it?
And well, I think the Court of Appeals still addressed the issues separate and apart from just stopping it.
Then why would the remand ever be necessary to them?
Because-
I'm trying to figure out level that this would go back to if it needs to be reversed.
The vast majority of the Court of Appeals opinion is based on its determination
Strict
that there's a strict
liability.
liability. And I think if this court's going to find that that's wrong, I think a remand is more appropriate for them to reconsider it because it is such a pervasive ruling in their ruling. There were times when they considered things separate and apart.
Something else that disqualifies that, and this is what I'm getting to. So, what was the jury told about that knowingly? What else was the jury told about what knowingly meant and which element of the crime it went to?
I'd have
Were
to
they
refer the
told
court.
anything else?
They got the standard pick instruction after the recodification. I think the fourth pick and fourth. They got the.
Did they get a definition?
I believe they did.
Did they get told what element of the crime the knowingly applied to?
I don't have the jury instruction in front of me. I'd have to refer the court back to the record. I'm sorry.
Because it sounds like knowing. I mean, if I were just an average juror and I heard knowingly, I would think it meant knowing his age, which is exactly what the other statute says doesn't have to be proved. So that would be error from the state's perspective, wouldn't it?
That would be, well, if they were
If
given.
the jury thought that what she had to know was his age, that would be wrong, wouldn't it?
We can't control what a jury thinks. We can control.
I'm asking if that, in fact, was what they would have understood from the instructions. That would be an incorrect understanding of the law, correct?
That would be
That's a
correct.
lot of
yes.
corrects in there, but
Yeah, but if they were given the standard pick instruction, which was agreed to by both the state and defense. I don't know that the court can reach that particular issue, and I don't know that it's necessarily appropriate for this court to speculate as to what a jury may or may not have understood. If
I'm just
they were-
asking a hypothetical question, which I think we do a lot. If the jury was told, if its instructions were worded so that a juror would understand that all she had to know was the age of the victim, that would be an incorrect statement of the law.
That would be in contradiction to 5204B, which says the state doesn't have to prove that.
Okay.
Counsel, I wanted to follow up briefly on Justice Breyer's question about voluntariness. The statute 21-5201A says a person commits a crime only if such person voluntarily engages in conduct, including an act, an omission, or a possession. Here we're talking about an act, so it would be a voluntary act. The jury wasn't given any instruction about a requirement of a voluntary act here, right?
Not that I recall.
And in the context of this case, do you have any comment on what would be required to show a voluntary act if that statute applies?
I think what the state presented at trial would be proof of a voluntary act.
What
that-
would the jury need to be told is the requirement of a voluntary act? Do you have to just move your body, or do you have to be non-coerced? Is there any element of the coercion that goes into that statute?
This is where the pick instruction on the intent, I think, covers that, because the instruction that was given defines what knowingly means, and generally it's understood. And I think the prosecutor made a brief reference to this, but I can't cite to the court to that for sure.
The instruction that was mistakenly given in your, I mean, that's.
That didn't need to be given, yes.
And the instruction that was given that is a culpable mental state, but then the defendant was precluded from raising any kind of, some was entered, but basically was not allowed then to enter any kind of mental disease or defect. And that would have been appropriate if it required a requisite mental state. You're kind of wanted both ways.
That's one of the issues that was raised. The mental disease or defect, if there is a mental state that's required for the crime, the evaluation that was obtained here simply did not meet the statutory burden for satisfying that. So what was admitted was what was appropriate given the content of the evaluation obtained. Sorry. Because there's no amount of proffering that I think defense counsel could do that could change the fact that Dr. Hutchinson did not find that she lacked the mental state necessary. In fact, it stated specifically the opposite, that she was very much aware that sexual contact with a 13-year-old is wrong, and I think it said Ms. Dinkle knew and knows this. So I don't think there's any amount of lawyering that can get around that. I'm sorry, does that answer your question?
Yes.
Okay.
Yes, thank you.
Any other questions? Thank you, counsel.
Thank you.
May it please the court, I'd like to turn for a second to Justice Stiegel's question. Yes, if the jury believed there was coercion, would they have acquitted? We don't know, because the defense was hobbled in their presentation of the coercion issue. The court allowed Officer Lodano, who was testifying as an expert, we can call him what we want, that the Facebook message was false. That's the proof of the coercion.
Can I follow up on that?
Sure.
Let's assume, for the purpose of the question, that the court ends up agreeing with you that the Court of Appeals was wrong and that at least voluntariness is required to be shown. What else do you have to demonstrate to get a new trial?
Well, I think with the issue of the Facebook, since it's false evidence that was presented, the due process standard is there any reasonable doubt that there couldn't have been an effect on the jury? I think
What's the procedural posture, though? Like, what path are you taking to get a reversal and a new trial?
Well, the fact that false evidence was presented, the fact that Mr. Struble did not present a computer expert where he knew they were going to claim the Facebook was false, which we did at the Van Cleve.
Mr. Knight, let me
yeah.
interrupt you there for just 1 second, and then I want you to go back to
Okay.
Justice Stiegel's question, but I'm a little confused about this. I understand that the state put on this officer at the time of the trial. You had evidence supporting that the Facebook post or message was genuine at the time of the Van Cleve.
Yes.
Did the state concede that point, or were they still disputing that point at the Van Cleve? Did they put on any evidence?
They put on no evidence.
Okay, all right.
The
Because
court-
you keep referring to it as an established fact as though
Well-
it's now undisputed, and I understand that that is your view, but I'm trying to understand the posture of the state vis-a-vis your view.
I guess the state or the district court could say the earth is flat and say, well, someone came in and said the earth was flat, and we could present 100 scientists that said that's not true.
Seems to work these days.
What?
Seems to work these
It
days.
seems to work.
Yeah.
But the problem is, Lodano testified, I'm not really an expert. I fool around. I mean, that was I kind of fool around with Facebook in my investigations.
Okay, I understand that it's your view that your evidence is much stronger.
Right. And there was a actual physical witness, Autumn, who was there when the Facebook message came in, who was never called. Then we have Mr. Struble not presenting the text messages which show the threats, and show the blackmail. The text messages from KH. The court itself, the district court, found that to be deficient, and the state never appealed that.
Well, then that gets back to my
Yeah.
question, which is you're arguing lots of evidentiary arguments, but aren't we procedurally in the posture of simply evaluating adequacy of counsel?
Well, yes,
So-
but you have to peel off the layer from the Court of Appeals that said,
And that was the start of my question.
Yeah.
I'm going to assume that we agree with you on that.
All
I'm
right.
still trying to figure out what you are required to demonstrate to get a new trial.
it's not just
Because-
adequacy of counsel under, say, Strickland standards for the Van Cleef. It's that false evidence was put in.
But so how do we get there? That's what I'm struggling with. Because this is all, the only way that you're still in court is because you had a Van Cleve remand to evaluate the effectiveness of counsel, right?
And also the genuineness of the evidence. We raised that.
But is a Van Cleve remand an appropriate forum to evaluate? I forget how you phrased it just one moment
Well,
ago, but the
genuineness.
genuineness of the evidence.
Yeah, whether the state put on false evidence, which they did, and
that's
argued.
and is there any case that says that's part of a Van Cleve remand?
Well, it's part of what we asked the Court of Appeals for. We said,
Procedurally, I understand the substance of
Okay.
your argument, but I feel like I have a sense that we're breaking new ground here, and I'm not sure you can point to a case that's ever done what you're suggesting.
And why don't you get there just with the lack of a voluntariness kind of inquiry or understanding of the trial court, and the Court of Appeals never dealt with it either.
Right.
The lack of that, isn't that just a legal question we can deal with?
yes, you absolutely can. And the problem is, the reason it's not been raised before is because the state didn't raise it. The state didn't say at trial, hey, we don't have, when Dr. Hutchinson was testified, there's absolute liability here. You don't have to show a mental state. We don't have to show a mental state. They didn't raise that. So they veer off this way, and then we're the ones that are deficient somehow, or trial counsel is. But I'd only conclude, if I could, by saying the statutes, 5202, 5201, are part of the statutes. They have to mean something, and they have to mean something in this context. Also, U.S. versus U.S. Gibson, the United States Supreme Court case, says silence on a mental state doesn't mean there isn't one. And that's what there is here. So there's silence by the legislature. We cited, I think, a fairly learned law review article that talks about this issue of why there should be this. The state wants to talk about policy. Well, really, do we want a policy that says a 6'2", 170-pound person can rape a woman and that she's going to be charged? It's not even a contest of who you believe, because she's guilty. Whether it's rape or blackmail or what it is, that's a policy. that we're creating by saying that there's at least no actus reus and mens reus requirement here.
Why didn't trial counsel request a jury instruction on voluntariness?
I think he was going a different direction with Dr. Hutchinson. It was not allowed.
Why wasn't?
And I agree with the state. It became sort of a coercion.
Why wasn't that raised as an alleged error on appeal, a jury instruction error?
On coercion, because that was never an issue. The state was never.
My understanding was that was the defense. That your argument is the defendants made an attempt to raise a coercion defense. It would seem to me that the jury instruction would have been requested, and if it wasn't requested on appeal, you would have said this was error.
Well, it wasn't requested. I agree. I think the problem here is it was an argument about what this was, whether it was rape or consensual, or it became that. But when the state never raised that issue that there wasn't a requirement of at least a general intent, then the defense counsel...
It's almost like invited error by the state.
Well,
That's
somewhat.
sort of what you're saying.
I mean, it's sort of rope-a-dope if you think about it. We're not raising this, so since you don't raise the instruction, so you're out of luck.
The bottom line is that all of this has arisen out of an unnecessarily complicated defense to the case. That's what it really boils down to.
I don't disagree, Your Honor.
Okay.
There are no other questions. Thank you.
Thank you. Court will take this matter under advisement.